James, the big question I've got is from a landlord. What is the quickest way to recover rent arrears from a former tenant? Sometimes it seems a case of throwing good money after bad. Over to you, my friend.
Well, the basic answer is there is really no quick way to do it. There's a number of factors involved. The first factor is thinking about how you got judgment against tenants in the first place. Now, if it was via the Section 8 procedure for rent arrears, then all the better for it. But if you have to go down a separate route, if the tenant simply vacated the property, and you have to go on a separate route through a small claims court, it can be quite extensive, quite costly and quite difficult. Thinking about the first instance, if you go down the Section 8 route, which is Section 8 notice under the Housing Act 1988, because the tenant is in rent arrears and you've got that judgment, then the best way to do it, depending on the amount of the actual debt itself, is probably to ask the court to order that the tenant attend court for questioning. There are many other options there, but if you've got a tenant in rent arrears, then it's probably unlikely they've got any assets, they don't own any other property, they probably haven't got cars. If they're on housing benefit, then it's going to be difficult. But the order to attend court for questioning is where a tenant is questioned before a court officer. Their incomings and outgoings are all examined, and they have to provide evidence of what they earn and what they get in and what goes out. And a court will sometimes give you make an order that X amount is paid each month. Now, unfortunately, on some occasions you don't get much back per month, but an order is in place. If the tenant is working, you can apply to the court for an order to attend court. An attachment of earnings order. You can't do that if a former tenant is self-employed. An attachment of earnings order gives the tenant the opportunity to make payments voluntarily. And if they fail to do so, then the money comes out of the former tenant's salary straight into your bank account. And that can be quite a substantial amount of money, again, if they show their incomings and outgoings. Other options are taking walk-in possession of goods to the value of the debt. Again, it all depends on what your tenant does for a living. If they have a job or if they have any assets, because most of the time TVs, sofas, if it's a furnished house, it won't have anything else. Some items aren't particularly worth a lot of money, so sometimes those goods can be seized, a note put on them. If the debt isn't paid in full in so many days, then the bailiffs will remove those goods, sell them at auction. And the problem with that particular route is that they only visit once, and as soon as they take those goods, you can't go back and get any more. So that's the debt basically paid up in full. If you followed the Section 21 procedure and used the accelerated possession route, which is simply a paper-based exercise, you fill in the papers, it goes to the court makes a determination upon if they receive a defence from a particular tenant. You don't get money judgment, you don't get judgment for any rent arrears if you just want them out. If you do decide at a later date that you want to recover rent arrears, you would have to go through the small claims court. Now that in itself is very expensive. If you instruct solicitors to deal with it, you will not recover any of the legal costs that you've spent, and this is why I get lots of questions from tenants about, from landlords, about, is it a case of just throwing good money after bad? Sometimes yes. If you don't deal with the arrears in the first place, then yes, it can be very expensive and quite prohibitive. I have a lot of clients who simply just want tenants out of the property and won't approach them anymore, and won't bother them anymore for their money. Under the accelerating ways to recover the money, I would always advise a landlord to try and combine a claim for possession of property, if necessary, with a claim for rent arrears, if there are any, because it is a lot easier than applying to the court via the small claims, because you have to go through filing of defence, potential directions whereby the court will tell the parties that there are steps to follow before a final hearing, and there's no guarantee that the judge, as I find out on many occasions, will find in your favour. Tenants sometimes, believe it or not, are known to lie about what they owe, and landlords have to prove in the first instance what they owe. So the quickest way is combine your any claim for possession of property you have to do with a claim for rent arrears. You don't have to follow the accelerated possession route. For under Section 21, you can use a standard possession procedure and combine it with a claim for rent arrears as well. It just saves a lot more hassle. And the way if they don't pay, the way of enforcing it, in my opinion, would always be, and if they don't work, to get an order to attend court for questioning. So they basically swear on oath that what their outgoings and incomings are, and a landlord will recover some money. But not a great deal.
That sounds very complicated. You can sort all that out for them, can you?
Absolutely, yeah.
Beautiful.
Yeah, we can do that. It's sometimes, depending on the amount of the debt, sometimes it's quite high. And one thing to always note is an order, a judgment against a former tenant, a debtor, is valid from 6 years from the date it's made. So you can basically enforce it 5 years later if they win the lottery, if they're very lucky, if they don't volunteer payments up then. So there are ways and means of doing it, and you can basically take your time.